Good afternoon, everyone. I am Guylaine Baudry, Vice Provost Digital Strategy and University Librarian. Welcome to the last talk of the year of the President's Speaker Series on Digital Futures. As part of this series, we invite leaders of the digital to share their perspective and spark dialogue and our thinking on how the digital shapes the present and future of our university. Concordia wants to provide digital environments that best meet the needs, experiences, and aspirations of all members of our community. We want to make our digital strategy a distinctive feature and a strategic advantage for our students and our university. Our roadmap includes 8 projects that contribute to shaping a next-generation university. We've made a lot of progress in the last few months, and you will hear more about us in the coming weeks. As part of the process to engage Concordians in conversations and reflections about the digital world, you will receive an invitation to contribute to one of the consultation activities we are organizing this semester that will be sent to you by email. And I invite you to send your information because we really need your involvement in our consultation activities. Today, we welcome Teresa Scassa, full professor of law, common law section, and Canada Research Chair in Information Law and Policy at the University of Ottawa. Her interdisciplinary research approach informs her examination of the laws that shape data governance, including privacy, intellectual property, and access to information laws. Teresa explores how the particular characteristics of data challenge existing legal frameworks, sometimes creating unanticipated and undesirable effects. As data grows in global economic importance, she has turned her attention to novel and pluralistic forms of data governance and to issues of access to and control over data in the public interest. She is the author of numerous books and articles. In addition to her scholarly writing, she regularly writes for audiences that include policymakers and the general public. Teresa has contributed to national and international debates and discussions around digital and data governance. She is the chair of Canadian Statistics Advisory Council, a member of the Canadian Advisory Council on Artificial Intelligence, and a member of the Digital Strategy Advisory Panel for Waterfront Toronto. Teresa is a graduate of Concordia University and also from McGill, nobody's perfect, and the University of Michigan. After the presentation, we will have time for a few questions. Please help me now welcoming Teresa Scassa. This is your place. Thank you, Teresa.
Thank you. Thank you very much. If Concordia had had a law school, I would have gone there too. Thank you very much for the invitation to speak to you today. As Guylaine has just mentioned, I began my university studies at Concordia University just a few years ago. And it was a big, vibrant, and diverse university that was unafraid of change, challenge, and innovation. I loved it. And I'm really delighted to be back here today and also to see that that embracing of change, challenge, and innovation remains the same. I'm really pleased to be here. My studies led me on a somewhat winding path to where I am now, a law professor at the University of Ottawa who works in the area of digital and data governance. This is a very broad umbrella, and it gets broader every year, which is a little bit unfortunate. That captures a range of policy issues that we face as we move more and more deeply into a digital and data-driven society. Digital and data governance challenges are being confronted by institutions and organizations around the world. They involve questions about how to collect, store, and use data responsibly and ethically. They consider who owns or has interests in raw, processed, and personal data. They ask how to design algorithms or adopt AI technologies built by others. Increasingly, they involve questions about how to share data to support research and innovation. They raise issues around the appropriate use and adoption of technologies, about the manipulation of data and the harms it can cause. And underlying all of these issues are legal questions around intellectual property law, privacy law, competition law, access to information, human rights, communications, and many other fields. Governments are concerned about outdated legal infrastructure, and in this context about laws and policies that no longer meet either the needs of innovators or the interests of the people they represent. Innovators are concerned about access to data and freedom to operate. Individuals are or should be concerned about privacy, fairness, equality, civil liberties, and democracy. So it's a busy area. When I agreed some months ago to talk about data governance, there was never any doubt in my mind that I would have to narrow the topic down, and I went through many different ways of framing the issues. And when the Clearview AI scandal broke in January of this year, I decided to use this as an example from which I could tease out a subset of law and governance issues because it raises so many, and it does so in interesting and disturbing ways. So on one level, then, this talk will be about Clearview AI and some of the specific issues it raises. On another level, I hope to identify for you some of the ways in which our current law and policy regimes are both inadequate or unprepared to deal with these types of challenges. I hope also to tease out for you the increasingly global nature of these challenges and the global governance gaps and their implications. Finally, so as not to leave you with a sense of overwhelming despair at our digital future, I will identify ways in which each of us can engage and hopefully make a difference. I thought I'd start by talking a little bit about facial recognition because Clearview AI is a facial recognition technology. And facial recognition technologies use algorithms that have been trained on images of faces in order to detect patterns that lead to the identification of individuals. It's a hugely controversial technology, in part because of issues of discrimination and bias, issues of false positives, and issues around the context in which it can be used. But the reality is that it's growing exponentially in terms of its actual and potential uses. And so, for example, facial recognition technologies are currently in use today in shopping centers, in retail stores. They're used for customer tracking, for advertising, for collecting demographic information. They're used for biometric information. They're used for tagging photographs in social media, on social media websites, for tracking school attendance in some schools, to identify VIPs at sporting events or other events where perhaps the operators of the event want to be able to identify VIPs and give them a special experience. They're used in an increasingly broad range of police and national security applications. They're also used by private security in a range of contexts as well. And these are just a few examples of contexts in which facial recognition technologies are used. And so this is really a technology, I think, to be aware of. It's developing very rapidly and has many possible applications. So what is Clearview AI? It's a company based in the United States. This is its mission statement from its website. I don't know how well you can read that. I just thought I'd put the mission statement up because it's a nice little exercise in rhetoric. Using Clearview, the bottom line states, law enforcement is able to catch the most dangerous criminals, solve the toughest cold cases, and make communities safer, especially the most vulnerable among us. So what could be wrong with that, right? Sounds pretty good to me. This is a facial recognition technology with a difference in terms of its application in the law enforcement context. This is a private sector company that's making promises about its usefulness to law enforcement agencies. It's not an in-house tool that has been developed by a law enforcement agency, for example, to use facial recognition within its own database of images. It's not a customized tool that is being supplied by a private sector company customized to the particular needs or requirements of a law enforcement agency. It's not a special procurement. It's an app for cops. Okay, and I think it's important to think about the governance issues that raises, and I'll talk a little bit about them in more detail later on, but if you think about it, it's one thing when a police agency is spending a lot of money to acquire a technology or have customized a technology that's going to be used, that it's going to use. There's a certain amount of transparency that comes with it, but this is an app for cops, and the transparency issues are really quite significant. Now, one of the big AI the big issues for AI technologies and data is, of course, that AI needs vast quantities of data in order to train and feed algorithms. So where does a facial recognition technology company get the data it needs, and how does it do so legally? So this is an important question to ask. In the case of Clearview AI, this is a quote from a New York Times story that really broke the story of Clearview AI and brought Clearview AI to public attention. And basically what Clearview AI does to get the images it uses, not just to train its algorithms, but its databases of images that it uses to carry out its facial recognition activities, is a database of more than 3 billion images that Clearview claims to have scraped from social media sites across the internet. And beyond social media sites, they've also scraped them from other contexts as well. So the data is scraped from the internet, and much of the data is user-contributed data to social media platforms. And this raises some really complex issues around involuntary data collection from individuals in what is constructed as public space. And so I'm going to talk a little bit about this idea of public space, but also think about a private sector company turning publicly accessible data into a service that is used by police, okay? And think about that movement of data from your social media site to law enforcement. There are also some linkages here, I think, that are worth thinking about in terms of the debates and discussions we've been having in Canada around smart cities and data governance issues. Because again, with smart cities, one of the things that has been most troubling in the context of smart cities is in part this idea that data is being collected about the activities, the day-to-day activities of individuals, their movements through public space, their movement in public spaces, their activities, their behavior within the places that they live, the cities that they live, and how that data is to be governed in ways that do not unduly exploit the individuals who essentially have no choice but to provide that data. So what is data scraping? These are just a few things that from the internet that give you illustrations of just how easy it is to scrape data. Everybody's scraping data. Data scraping is a widespread, ubiquitous practice. It's a way to gather data. And in an increasingly data-driven society, then it becomes obviously an important source of data. It essentially involves the automated harvesting of data or images from the internet. It's widely used by just about everybody. Private sector innovators like Clearview AI use data scraping to harvest the data that they need. You see companies harvesting data from their competitors' websites in order to populate their own websites. Civil society groups use data scraping. Governments use scrape data. Researchers scrape data. And think about your own role within the research community and how researchers access data. And there's a really interesting debate in the research community around the ethics of scraping data. And I think that that's an important debate or discussion to have. Now, data scraping raises quite a number of law and governance issues. Does it infringe copyright when images are being scraped? And I'm going to talk about that in a minute. Is it a breach of contract? Most websites have terms of service. If you ever read those terms of services, most of them will say data scraping is prohibited, right? Anyway, is it a breach of contract when you scrape data? Is it a trespass to chattels? Data is hosted on servers. There was some case law in the United States that hasn't had a lot of traction elsewhere that has found that it's a form of trespass to go onto a server where you don't have permission and to scrape data. Usually they've done that in contexts where the scraping activity is such that it actually inhibits or slows the server's performance. Is it a breach of criminal law? And there's been some debate and discussion about that in the United States. Does it breach privacy rights, which is an issue that comes up in the Clearview AI context? Is it unethical? If, in fact, everybody's scraping data, but you have terms of service that say you can't scrape it, there may be privacy implications, there may be copyright laws that you're ignoring, then is collecting or harvesting data in this way to use in other contexts simply unethical, and what are the implications of that? So there are a range of unresolved issues around data scraping, and of course, this is how Clearview AI gets its data. Now, in Clearview, so I'm going to start to talk about some of these issues, and I'm going to start with the privacy issue. the privacy issues raised by Clearview AI, which I think are really quite interesting. So Clearview AI uses data that's been provided by people, photographs or images that are posted to the website. Those contain personal information, of course, the images of the individuals, but also may be protected by copyright, and I'll come back to the copyright issue in a minute. But as you can see these are from Clearview AI's website. They maintain that they only search the open web, that it's all, they don't bother with private or protected information. We only collect and search publicly available images and data. And so they're making a claim here about this stuff being in the public space, and therefore there's a free-for-all in terms of the ability to access and use that data. And so this is an interesting debate that's going on right now in the privacy world, although I think within the privacy scholars communities, it's not that much of a debate because everybody, I think, is on the side of, or most people are on the side of, the idea that there needs to be some contextualized understanding of privacy in public spaces. But it is nonetheless a debate that's happening at the innovator and obviously public policy levels. So how do we understand a concept of public space in a context where we have rapidly evolving technologies? There was a recent Supreme Court of Canada decision, the Queen versus Jarvis, which looked at, which involved a high school teacher who used a hidden pen camera to, he would engage in conversations with female students in the hallways and film down their shirts. Okay? And so one of the issues in that case, which went all the way to the Supreme Court of Canada, was whether those students had a reasonable expectation of privacy. And you're probably thinking, yeah. It had to go to the Supreme Court of Canada for us to get there. But part of the problem with the concept of reasonable expectation of privacy was this idea that these were young women in the hallways of a school, and those were public spaces, and they were just engaging in conversation, and therefore, if you're in your public space, you have no reasonable expectation of privacy. Fortunately, the Supreme Court of Canada said, when you're a young student being cornered in a hallway of your school by a teacher to whom you feel obliged to talk to because they're in a position of power over you, and they're filming down your shirt with a hidden camera, you do have a reasonable expectation of privacy. The concept of publicness doesn't outweigh some of these other factors that we need to think about in terms of public space. And so the question is, when you post pictures on Facebook or Instagram, are they just out there in public space where you have no expectation of privacy, or do you have some expectation that they're not going to end up in a database on which facial recognition apps are run in order to serve the law enforcement community for some companies' commercial interests? So how do we understand privacy contextually in that context? Now, that's the privacy in public space issue. But of course, in Canada, these claims that are being made by this company that markets its products, its services in Canada, are not true in Canada. In Canada, I've put a provision of the law up there because I'm a law professor and I can't help doing things like that, but you don't have to feel compelled to read it because statutes are kind of boring. So I'll tell you about it. But in Canada, in PIPEDAR, a much maligned private sector data protection law, there is an exception to consent for publicly accessible information. So if information falls into the category of publicly accessible information, then it is, then you don't need consent to collect, use, or disclose it. But the definition of publicly accessible information is very narrow. It's only what's set out in the regulations, and what's set out in the regulations are things that are like telephone directories or public registries. And then you're only allowed to collect and use or disclose that information without consent if you're doing it for the reasons for which that information was made public and not for other purposes. So in Canada, it would be a breach of the private sector data protection laws to scrape publicly available information such as Instagram photographs or Facebook photographs, and that would breach the law. Now, this is something that when you're like a privacy nerd, you get really worked up about things like this. In 2018, the Ethics Committee of the House of Commons issued a report in which it made recommendations for the reform of our personal information protection and PIPEDA, anyway, of our private sector data protection law. And one of these recommendations was that the government of Canada modernize they receive submissions from the private sector, modernize the regulations specifying publicly available information in order to take into account situations in which individuals post personal information on a public website, and in order to make the regulations technology neutral. In other words, they recommended that the government change the law to declare open season on your data that you post on social media websites, because this is really valuable data to private sector companies that want to scrape it up and use it for who knows what, including facial recognition apps for cops. Okay? This is the kind of stuff that's really dangerous, because I highlighted the words in red: modernize, make regulations technology neutral. This is the kind of comforting language that makes people think they're doing the right thing. But this is an amendment that would have extremely serious implications. And if and when we ever get a PIPEDA reform bill, which I hope we do, you can be sure that I am going to be looking through it to see if this an amendment of this kind made it in, because I think this is very dangerous. This is open season on what is shared online without a nuanced discussion of what people's expectations are in terms of privacy. In terms of privacy gaps and challenge, I just want to note that investigations have now been launched into Clearview AI by the Federal Privacy Commissioner and by commissioners in 4 provinces with 3 provinces. I don't know why I put 4 there. 4 investigations in total, 3 provinces with private sector data protection laws. These investigations are going to go ahead. I predict that they will find that Clearview AI's technologies breach Canadian privacy laws. And then we're going to be faced with the same enforcement issues that we're being faced with right now with respect to Cambridge Analytica, which is that you're going to have a US-based company that says, who are you? Who is the Canadian Privacy Commissioner? I don't really care. Because all they can do is make recommendations. And for anything to be enforceable, there's another process that has to go through the federal court, and even then you have to figure out if the judgment's going to be enforceable. Right now we have privacy laws that set out privacy principles but provide very little in the way of actual enforcement. And so this is a problem as well. Maybe the previous slide you were feeling good when I said this violates Canadian privacy law. The problem is that violating Canadian privacy law is not a big deal right now. And so again, in terms of law reform, we need to be thinking about it being a big deal. And if you look at the GDPR, for example, the new European General Data Protection Regulation, enforcement is a very big part of the GDPR, and that can clearly make a difference. So that's just flagging some of the privacy issues for you. And I just want to also note here the issue of global the global issues, because of course you've got a US company that is making statements about the legality of its actions based on US law, which with respect to privacy are pretty much the lowest common denominator in the Western world. But their activities actually breach Canadian law where they are marketing their services, not to mention European law. And so you start to see how the creation of global norms is also tremendously important in terms of shaping how businesses are allowed to structure their businesses. So I'm going to talk a little bit about copyright now. Am I? Yeah, sorry, copyright law. And this photograph is from an article that was written by a California journalist. Now, California actually has just enacted privacy laws that have come into effect in January of this year. She sought to exercise her right to access under privacy law and to demand removal of any images of her contained in the database. And so the original image, search image, is that one that she was required to provide to them. And then they searched their database and provided her with those images that they had about her in the database. And she wrote an article about it. There are a mixture of copyright and privacy issues here. She was using the access rights under privacy law, but of course, individuals, the owner of copyright in a photograph, it tends to be the person who has taken the photograph. And so for most people who take selfies and post them on the internet, for example, or take photographs of their family and post them up on the internet, those individuals are the owners of copyright in the images. And so then the question becomes, well, if those images are scraped, and put into a database, isn't that copyright infringement? And if the database contains 3 billion images, isn't that copyright infringement on a grand scale? And we're all told, of course, that we mustn't be pirates and download music and we have to respect people's copyrights, but didn't our copyrights just get massively disrespected? So that's the question. There's actually case law in Canada that makes it clear that scraping photographs in which copyright subsists is copyright infringement. So that's a pretty straightforward question. There may be issues around fair dealing for the purposes of research, depending on why you're scraping the photograph. So it's prima facie, at first glance, it's infringement. It may be that you can rely on a fair dealing exception. And I think that's important to flag. I'm just going to mention very briefly another case that is working its way through the courts still, I think, from a Montreal artist, Adam Basanta, who is being sued for copyright infringement in relation to his art installation, which uses AI in relation to a database, a very large database of images that he has created by scraping images of artworks from the internet. And so in this case, and it's a really interesting case about a very creative application for it, the images are being scraped, there's copyright in those images. One of the issues is that copyright infringement, and is it fair dealing? And it may well be fair dealing. Certainly this is a very different kind of context from Clearview AI. You don't have the same breach of privacy rights at the same time, which I think would militate against fair dealing, and you also have a relatively non-commercial purpose. But there's some interesting issues there. It's an interesting case to watch, and it shows you how little we know about how some of these copyright issues are going to play out in the AI context. So I'm just going to throw that in for just to make it a little bit more complicated. But the other thing to note is that in the copyright field, there's a lot of debate and discussion around text and data mining exceptions to copyright infringement to facilitate the development of AI technologies and innovation. And text and data mining is a different activity from what Clearview AI is engaging in. Text and data mining is really a process of extracting data or information from texts or images, extracting it as data, as opposed to copying those images or text and storing them in a large database on which you then run searches and use algorithms. So there's a little bit of difference there. But there is a debate and discussion, and one of these days Canada is going to have to address this issue as well. Do we need a text and data mining exception in copyright law? And if so, what shape should it take? So this is another issue that remains to be addressed on the home front. Now, search engines, in this case, Clearview AI is relying on an exception in the copyright legislation in Canada and the United States. This part is at least fairly well harmonized at the international level for online services and information location tools. Essentially, Google, to have its search engine, goes out and scrapes data and scrapes images, and that's all part of operating this particular service. And for us to be able to profit or benefit from these services, there needs to be an exception to liability, because so much of what's copied is copyright protected works. If you think about Google Images and you go and you put in some keywords and you get a selection of images, many of those are copyright protected works. So there is an exception in the legislation for information location tools like search engines, and the idea is to be able to allow these useful tools to function for all of us. Clearview AI is taking advantage of that, saying that the database that they've created is really an information location tool, because when they run a search for a client and they produce search results, the search results include the URLs that point them back to those websites so that they can themselves visit those sites and copy down the personal information, the name and other personal details of the individual. So they've actually leveraged this exception in the Copyright Act to create an exemption for their activities. And I think that's an interesting example of how when you're drafting laws and policies in this area, you have to really be careful, because they can take a sudden and unexpected turn. Now, it doesn't mean a court would that was faced with this issue of copyright infringement would say that that Clearview is actually an information location tool. I think there's room for interpretation that it's not, but it does complicate the matters. And so what this does is, in essence, is shift the onus onto the individual. You have to notify Clearview AI that they have works in their database that infringe your copyright, and they have an opportunity to take those down. And as long as they do that, then they haven't infringed your copyright and you can't do anything about it. So the vision of that class action copyright infringement lawsuit using statutory damages to bring Clearview AI to its knees just disappears or becomes much more complicated. So that's copyright. Now, there are also issues here about ethical AI. I've just put in some provisions from the Montreal Declaration on Ethical AI relating to, that I think are most applicable in this context. But there's a lot of talk about the need to set rules or guidelines for the development of ethical AI so that we don't run into this problem. There are also concerns being raised about it's a challenging area because if you make your rules too soon before you understand the technology, you risk having rules that are inappropriate or create unexpected loopholes or have unintended effects. But if you just have ethical norms or standards, you don't know how they're going to be actually implemented, applied, or used. And so that can be a challenge as well. So in this case, with ethical AI, in something like facial recognition technology, you want to be concerned about the design, the quality of the data being used, the quality of the algorithms, avoiding false positives, avoiding discrimination. So there are ethical issues around how you design the technology. There may be a need for your technology and algorithms to be reviewed for ethics. There are ethical issues around adoption, and I'll talk about that more later on. And then the issue of, is ethics enough? And in the red box, you'll see what Clearview AI claims on its site. Independently verified for accuracy, an independent panel of experts reviewed and certified Clearview for accuracy and reliability. And I think this is what we call ethics washing, right? Where you just pretend that you did something. There's no information anywhere about who these independent experts were or what their review involved. It's just like, don't worry, we got it. We did our review, we're golden. And so with ethics, I think you get issues of ethics washing. I'm going to move on now. I could say more about any of these things, but I want to specifically talk about some of the transparency and oversight issues because these, I think, are really serious ones. First of all, in terms of transparency, we are starting to get a sense of how widely Clearview AI's technology is used because they got hacked. They got hacked by somebody who took their client list and made it public. That spurred a lot of law enforcement agencies in Canada to come forward and very abashedly say, when we said last week that we weren't using it, well, what we meant was we were using it, but, anyway. So they got hacked, and that's how we know just how broadly it's being used. And if you look at their website, they claim they're a law enforcement tool, and they're keeping us safe from child predators and from terrorists. But it's used by Macy's, Walmart, and the NBA. There may be child predators and terrorists there, but it's probably being used for a whole lot more purposes than is part of their marketing. Beyond that, and these are just some clips from news stories where you get these kind of admissions that police services are using this technology. The police adoption of these technologies, and what you see, I didn't put some of these statements on there, you also get fairly defensive statements saying it works. It helps catch bad guys. It helps identify child victims. So it's a good thing, right? It may work, and it may be good in some circumstances, but there are things that you need to do first before you adopt the technology. Transparency is one of them. You need to have a public debate about whether you want your police services to use this kind of technology, right? There should be some kind of public debate, municipal council, police services board, somebody should be talking about whether this is something we want to do, whether this is the right technology that we want to use, what safeguards are part of that technology. You also want to have the conversation about in what circumstances, since there are risks and issues with facial recognition technologies, which are the crimes for which it should be used? What kinds of limits do you want to put on the use of it? Should it be restricted only to the most serious types of crimes? Should it be for absolutely anything? And so that's a discussion that we simply didn't have the opportunity to have, and that in and of itself is a problem. The other issue is oversight. And again, you get these statements saying, but it works and it catches bad guys, and we should be glad. Any organization that has a database has employees that go trawling through the database. Okay? This is a problem that's known. Hospitals struggle with this issue of people going into the patient database looking for information. The Canada Revenue Agency cannot stop people from going in, employees from going in. Well, not all of them are, I don't want to paint them all with the same brush, but they have a chronic problem of people going in and looking at people's tax returns. And the police, as you can see, these are just a few headlines that I've thrown up, have a problem with databases being used by police inappropriately. So if you are going to adopt these kinds of technologies, you also need to have policies in place to ensure that they're used appropriately and accountably. You need to decide who and at what level gets to use the technology. You need to decide who they have to ask for permission or what kind of paper trail there's going to be. You need to have an audit trail with respect to the database so that you can tell who has looked at for things and at what point in time. You can imagine this tool, right? A police officer could go to a bar off duty, see an attractive woman, take a surreptitious photograph of her and run it through the database to find out who she is and where she lives. You could use it to, you could photograph peaceful protests and use it to identify who the protesters are, right? It's capable of all kinds of misuse. And so again, it's not enough to say, well, we catch bad guys. You need to have transparency, you need to have oversight, and you need to have accountability. Now, the Privacy Commissioner is investigating the RCMP's adoption and use of Clearview AI, and it'll be interesting to see what comes of that. And I want to leave time for questions, so I'm not going to get into details into this argument. I'll just say that the Privacy Act, if PIPEDA, the private sector data protection law, is out of date, the Federal Privacy Act, which deals with public sector privacy issues, is even more archaic and is not at all designed for a context in which government is not the body that has collected and compiled the information. It's really governance, privacy governance legislation for the government as collector and user of its own data. It's not designed for government as user of apps that rely on data collected by the private sector. And so it's not a great fit, although I think this section 6.2, see, I can't stop myself from putting provisions of the statute on the screen, but I think this one may be interesting and may have some interesting implications, especially because of a recent Supreme Court of Canada decision that imposed certain obligations of accuracy on data that was obtained using, in that case, standardized tests. And so the question was that data reliable? To know that, you have to analyze the standard and study the standardized tests. So it puts some onus on the government to be sure that the data analytics they're relying on are trustworthy. So I've given you just a little bit of the digital governance web from Clearview, starting with Clearview AI and expanding out to the range of different issues that it raises. And that's just a subset of them, and I've gone through them fairly quickly. This is why I find it such an interesting data governance example. There's a lot going on there, and I think it should be clear that there are a lot of unresolved questions. There are a lot of laws that are not perhaps up to snuff. There are global standards that we need. And I think it creates for us an extremely challenging situation, particularly in a context where these technologies are moving so quickly ahead. And so I promise not to leave you in a complete and utter state of despair. So in terms of where do we go from here, I think the challenge is to make laws and norms that are sufficiently flexible for a rapidly evolving context, but that also have teeth. That's a pretty big challenge. It sounds really simple. It's a really big challenge. That's not easy to do. We also, as citizens, I think, have to be engaged in order to ensure that our digital future is one in which we would like to live. And I think that means we have to not be passive about these sorts of things, that we have to when these issues come up, that we have to engage with them and we have to really think about what it is that we want. We also have to resist binaries in the debates and discussions because they're too convenient and they're used all the time. This is one this is from Dan Solov's book, but I've heard it in the context of Clearview AI, and you hear it all the time if you work in the privacy field. If you've got nothing to hide, you shouldn't worry about government surveillance. right? If you got nothing to hide, you shouldn't worry about the police using facial recognition apps. Well, yes, you should, and I hope I've convinced you of why you should so far in this discussion, quite apart from issues of bias, discrimination, the fact that the data on which they're based may be flawed, and all of those issues. There's also the transparency and oversight issues, and the fact that these technologies are capable of significant abuse and misuse, and we should be concerned about all of that. So resist that kind of binary. Resist the if you are not with us, you are against us binary. Okay, this is Clearview AI on its website says it helps to identify child molesters, murderers, suspected terrorists, and other dangerous people quickly, accurately, and reliably to keep our families and communities safe. And if you oppose it or object to it, what kind of monster are you? Right? So resist those binaries as well. This is a false argument. The other binary that I see all the time, and this is a challenging one, because innovation is a social value. You've got, under innovation, you've got jobs, you've got productivity, competitiveness. These are all things we want to be as a society. We want to have a strong economy. We want to be innovators and not just users of other people's innovations. We want all the good things that come with it. What we get told, though, is that if you want innovation, then you need less governance, because governance is a barrier to innovation. Right? So the more privacy protection we have, the less innovation there's going to be. In a sense, you can say the reason why Clearview AI can just come up with this app and go out there and make all this money is because there's very little privacy protection in the United States. And that's true. All right? Less governance, more innovation. But is that the kind of society that we want to live in? All right? There's got to be a balance between governance and innovation. And so we have to be really careful about this governance innovation binary that, you know, that if you want the innovation, you've got to give up on the governance. Could we have innovation in technologies that are ethical and appropriate? Could we, you know, are there ways in which we can have more of a balance between governance and innovation? It's also important to test and challenge analogies. So is Clearview AI like a search engine for the purposes of copyright exceptions, right? Is it actually entitled to rely on this exception for search engines or information tools? Got to challenge that analogy. Are social media postings the equivalent of online company directories or public government registries? Are they publicly available information? Should we just say that this is also, that there's no rules of consent that apply? Is scraping data from social media sites the privacy equivalent of watching someone walk down the street? That's the public no privacy in public space thing. The idea that you can't tell people that they can't look at other people when they walk down the street. If you're out in public, you're in public view and people can look at you and they can think about you and they can comment on you and there's not much you can do about it. But is that the same as scraping their photographs from social media websites and then using them in facial recognition databases? So we've got to test and challenge some of these analogies. It's also important to get involved, and I guess the good news is there's so much going on in the law, the policy, governance area right now at all levels of government, municipal, provincial, federal. There are law reform initiatives, policy debates, consultations going on. There's lots of room to get involved at those levels in those types of activities. We also have civil society actors, both national and international, who are engaging heavily in that context. In Canada, we have some really good civil society groups who are much less well-funded than their counterparts in the United States, and they do an awful lot with very little. They are always looking for people who want to be involved, engage, or donate, right? So there's involvement through civil society. There are issues that arise in your own places or spaces. This university is going through a data governance strategy strategy development. There are issues that arise in workplaces and ways to be engaged in workplaces and in communities as well. And what's happening in Toronto around the Sidewalk Toronto project, I think, is an example of how people became very engaged and as a result of that engagement have managed to get some significant concessions from Sidewalk Labs. And then, of course, you can also practice on your own data, governing your own data. There are so many ways in which and I admit that it's a very difficult and challenging thing to do. But there are ways in which you can ask questions about what's going to happen to your data, or how your data is going to be used, or who you want to share your data with, or for what purposes. And there may be and there are increasingly privacy protective technologies and search engines and other things that you might want to look at and adopt. So this is another thing that people can do, is to start thinking about what they want in terms of not just governance of their own data, but privacy protective technologies and other services that might allow them to do more. And I'm going to stop there because I hope we'll have time for some questions. I hope I've left time for some questions, if anyone has any.
Hi, thank you for the talk. It's really amazing. I've been following the Clearview AI since the day it broke, and it's been very scary. I also read about a case in the US where a guy was in court because he was identified through AI, but he couldn't get the judge to say it's inadmissible because it was a tool that the police used, but there was no way he can get out of it. Is that happening in Canada right now?
I don't know of any specific cases of people who've ended up in court because of AI, but the Ewart case that I flashed on the screen briefly, I think is a really interesting and cautionary tale. Now, it's a Supreme Court of Canada decision involving, Ewart was a Métis man who had been incarcerated, and the Correctional Services Canada was using these tools. They weren't AI per se, but they were a kind of standardized tool that had been developed to assess risk of recidivism or carceral needs and so on. So how his life would unfold in incarceration turned on how what answers these tools would generate. And he objected to that, arguing that the tools were not adapted to Indigenous offenders and therefore couldn't be producing appropriate results in his case. And he eventually won at the Supreme Court of Canada level, which is a great thing. But the cautionary tale lies in the fact that it took him 20 years to get there. And that's a little long, right, to have to kind of slog it out. It took him 20 years to get there, and he got there on the interpretation of particular wording in a statute. He had charter arguments as well that were based on his charter rights to be free from discrimination. And the courts basically, the Supreme Court basically said, well, but the onus is on the person raising the charter argument to establish that there has been discrimination. And so that's the other thing. It's not only can you challenge the use of the test in your particular case, but if you're arguing that the test is discriminatory, what's your burden of proof going to be, and how on earth are you going to meet that burden of proof, A, within a reasonable budget, and B, without access to the data or the algorithms? And there are increasingly problems around both of those things because of transparency. And then even if you do have access, of course, you need to hire experts who can run the analytics for you and do the analysis and provide opinions. So it's extremely expensive. So I think that, these issues about, what's going to happen when you get into court because you've been selected through an algorithm or pinpointed through an algorithm, I think those are really interesting questions, and I think we have a lot of work to do in that area as well.
Okay, we'll take another question.
Hello.
Hi.
I have a question about, so you made it clear that doing the data scraping in Canada is illegal, definitely by third parties. I'm wondering, and maybe that's inaccurate and you can correct me if I'm wrong, but I'm wondering, do companies that have that data provided to them willingly, like Facebook, can they scrape their own data? Or does that only apply to third parties that are coming in to use an API to scrape that data from somebody else?
I wouldn't want to be taken to say that it's illegal. It does raise interesting issues about whether it's a breach of contract or whether there are copyright issues. Depending on the purpose for which the data is scraped, for example, it might be fair use, or fair dealing under copyright law, if it's being scraped for research purposes. And so there might not be copyright infringement. It might not be data in which the host organization has copyright. And so images on social media sites, the copyrights are owned by individuals, but not by Facebook. So it's not going to be Facebook coming after you, for example. The terms of use, there have been some debates or discussion about whether it breaches terms of use. the consequences for breach of terms of use are not that weighty. So it's complicated legally. I think most people just go ahead and do it and hope nobody notices.
You're talking about scraping the data.
Scraping the data, yeah. In the research context, it's really interesting because some companies are now creating APIs that allow researchers and others to access data on their websites as an alternative to scraping because the companies don't like the scraping. But the problem with APIs is that they basically allow you to access a subset of data. And what researchers may want might be data other than that subset of data. And so then the question becomes, if it's a researcher or a civil society group, is there a justification for scraping data beyond that amount? These are really interesting questions because if you're in a data society where there's unequal access to data as well, then I think there are really interesting questions about where the public interest lies with respect to data scraping, and in what context does data scraping serve the public interest as opposed to being contrary to it. It's a really complicated area.
Right, yeah. Because the general narrative is that more data makes our lives better. I think that's what we're being told.
Yeah.
And I'm curious, is that your opinion? Like, would you argue that all of this data and this analysis and being able to scrape this data is actually making people's lives better? Or do you think the ethical implications of it kind of override any of the benefits that we might be seeing as human beings?
Yeah, I think that's an interesting question, and I think that the question, and in many ways, it's complicated and fairly case specific. I mean, there may be things that we could do with data, for example, that might lead to medical treatments or cures that we hadn't thought of or wouldn't otherwise be able to arrive at, or perhaps offer some solutions for climate change, just in terms of the amount of data that we can process. So there may be context in which more data is actually in the public interest and is something for good. Whether I need to have all of my appliances and some kind of home personal assistant siphoning off data so that I can get, more personalized ads or who knows what chucked at me, whether that's in the public interest or my interest, that I'm much less sure of.
I'm with you.
Yeah.
Thank you for your question. We have time for another question. Is there a question at Loyola, Paul? No, not for now. Okay, go.
Thank you, Teresa. I'm just thinking about the tension between governance and innovation, and also the lack of options when, as an individual, you don't have an opt-out option if you want to use a specific technology. Yeah. It's all or nothing. There's no subtlety there. You can't opt into certain aspects of it and not others most of the time. There are some privacy settings, but on the governance tension side of things, what's interesting to me is some of those governance conversations can't really happen until the technology has arrived and actually manifests some of the tension that's part of the technology. Mm-hmm. And some could argue that that's the way the system is designed, where we put things out and then we figure out how to fix them. It's got a lot of unfortunate side effects in terms of some people end up paying the burden of being those new cases or bringing those court cases to bear. But it's I'm wondering if you have thoughts about that tension and that kind of question.
Yeah, and I mean, I think that is a challenging problem, especially since things are moving now even faster than they were moving 10 years ago. The speed of innovation around data and digital technologies. And so, that does become difficult. And I think that's partly why we're starting to see a lot of discussion around standard setting and around ethical guidance and so on. And those are, and they sort of set broader principles. Ethical guidance really talks about how you should do things, what your objectives or goals should be. The federal government's digital charter was something similar in terms of a set of principles that could be applied as laws and policies are developed. So we're seeing a lot more of that. My concern with that is, of course, it's not worth much if you get half-hearted attempts or ethics washing, or just, nobody's really, and there's been a lot of interesting stuff around how ethics are being implemented in major corporations. A lot of interesting discussion about that. And so I think that, there may need to be some sort of combination or marriage between the broad principles and then serious remedies or enforcement, or significant tools that can assist individuals, whether it's certification by independent bodies that can, there's some of this, so it's the kind of the softer norms or standards, but there's got to be something backing it up. And what we've got with PIPEDA right now, our private sector data protection law, is the soft norms and soft guidance, which was initially the concept, but the enforcement is lacking. And the soft norms and soft guidance worked perhaps better in an era where the issues were less dramatic and impactful, and is not working now. And so now I think there's a lot more pressure to look at enforcement. So I think that we have to try and find that kind of balance between principles, softer principles, but some level of enforcement.
Thank you.
Thank you. Olivier?
Thanks, Teresa, for a wonderful talk. Truly enjoyed it. I also like to thank Paul for the question, because he set the table perfectly with where I was going with this. In your talk, you talk about questioning binaries. And I have one for you that and honestly, I don't have the answer to this question. I usually ask questions for which I have the answer, but in this case, I don't have the answer. So this is a very friendly, open question. But there are some binaries in law itself, in what law is. Mm-hmm. And the main binary that I keep hearing is the liability rule versus the ownership rule. So, if you own something, there are exceptions to your property right, but property is a thing. And then if you use somebody else's property, then you have risk leads to liability. And so this kind of overarching, these themes, these two, the property versus risk or liability versus ownership rhetoric, is embedded in the way that we understand these situations. And I'm trying to see if these concepts still work in the digital world. I mean, from my perspective, things like, a diffuse risk, or the economic value of somebody's property taken as a single entity is close to zero. But when you amass it into a vast trove, then it's gigantic, the value. And so are the concepts of liability and ownership still the ones that will take us to the digital frontier, to the digital world, that will allow us to recuperate the transformative nature? And what are the other ones that we could think about? And honestly, this is where I had to do a PhD in law, and I still haven't figured it out, right? So fair warning that I don't have the answer to these questions, but I would love to hear you talk about liability, ownership, and how we break away from this. Because the soft law and going to the court, but the court doesn't really have any power. And even if you got a ruling, then you can't enforce it. All those questions go back to these two fundamental tenets of our legal system.
Yeah, no, that's a really interesting question. One of as you know, I've done a lot of work around data ownership, and I always use the term in my mind with little air quotes around ownership, because I think it's a concept that doesn't fit and doesn't work with data. And yet it's a concept that's very attractive to a lot of people. So you hear people talking constantly about ownership of data. In the EU, there have been a number of studies done with a view to possibly creating data ownership rights, some kind of directive that creates specific data ownership rights. Fortunately, most of those studies have ended with people throwing up their hands and going, it just doesn't work. But you also hear people talking about owning their own personal data. You hear the ownership is the paradigm for data, right? That you own data. And yet data is the kind of thing that simply cannot be owned in any conventional sense of the word. And so I think that what it seems to me we're moving to in the context of data rather than an ownership are things like interests in and control over, and perhaps with control over some level of responsibility or accountability. And so those concepts are much softer as well. But in part, the idea of interests in data recognizes that in any set of data, there may actually be multiple different interests that you can't, that assigning ownership simply doesn't make any sense. I mean, this was part of the discussion in the Waterfront Toronto, the Sidewalk Toronto context, which was, who owns data collected in public spaces within the city? Can it be a private sector corporation? Is it government? Is it the people? And if it's the people, how is that ownership manifested? And I think it really was a discussion about interest rather than ownership. But this is, I think this is one of the areas where we're starting to see different ideas emerging. And one of the things that I think is very interesting in the context of personal data, rather than any idea of ownership of personal data, is this the growing the recognition of people's interest in their personal data, and then growing rights of control. So this is part of what you see in the GDPR in Europe is more and new types of control over personal data for individuals, whether it's data portability or a right of erasure, a right to be forgotten. These are rights that give people unprecedented levels of control over their personal data. And so it's not ownership, it's data often that's in the hands of other people, but it's a right to take it away, move it somewhere else, control it in new and innovative ways. And so I think that we're going to start to see something like that. So I don't know if that doesn't even address the liability side of your question, but I think that we are in a context where some of these just don't make any, we keep trying to fit things into these boxes and they don't fit well.
So we have time for one last question that I think will come from Loyola.
Is it on? Can
Yes.
you hear? Okay.
Yes.
As a lay person, I kept thinking about, does it matter to me? And the image part, it doesn't affect me, so it didn't worry me. But then I started thinking about this location service, the Google map. And so maybe this is my ignorance, but, it worries me more than the image. And I think, so let's say that, I went out in a speed limit, and the police can potentially give me a fine. So how does that kind of a data treated? Because I'm sure there's a lot of people who go over limit, nobody is getting a fine. So how is it protected in terms of the privacy of my data?
You mean this is data collected by your car about your driving habits?
Yeah. Oh, and then also the Google Map. I like Google Map, but I want them to have those information and traffic. But meanwhile, as an individual, I don't want them to keep my individual data because I'm sure, everybody go over the speed limit. and I just don't want to have this, so how is it kept, and is it, how is it those data is treated?
Yeah, I think those are really good questions, especially as we invite more and more smart gadgets and smart appliances into our lives that are collecting data. And sometimes involuntarily, it's going to be hard to buy a car that is not, buy a new car these days that's not collecting data about you and about your habits. And so I think one of the things that's interesting to think about is not only, what do private sector companies use that data for, where it's a private sector company collecting it, how do they intend to use it, but also to think about the relatively porous relationship between the private sector and the public sector when it comes to these data. There's all kinds of ways in which law enforcement can, for example, gain access to the data that's on your devices or on your cars, and they can do that legally through production orders or warrants. Although the production order and warrant system really hasn't been updated to a context in which everything we do is being monitored and leaving a data trace. So in terms of, the level of intrusion, I don't think that's been appropriately addressed in the criminal code. But there is this porosity so that, Alexa knows things that she may have to tell the police about what's going on in your home. And your car, you'll have the electronic data recorder in cars that can be accessed by police. Insurance companies are interested in that data. It's going to be, if it's collected, there are going to be people wanting to use it in all kinds of different ways. And I think this is something we also have to come to terms with and wrap our heads around.
Thank you very much, Teresa. Thank you for the question at Loyola. So here at Concordia, when we surveyed our students, only 12% of them told us that they know what Concordia is doing with their data. So there's a lot of work for us to be doing. And thank you for this very interesting talk and for the concept that you brought, but also in a very concrete manner and even some insights to engage in this very important issue. So thank you for your participation to this last talk of the season. Thank you.
Thank you.